Welcome, everyone. We're going to get started in just a moment here. My name is Eugene Soar. I'm at the clerk's office. Sorry for making you all turn around. I just want to let everyone know that this is being live cast to YouTube and also recorded, so just be aware of that. And we will get started in just 1 second. Thank you. All rise. The Honorables, the presiding judge and judge of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. President of the State and this honorable court.
Thank you, Mr. Soar. Thank you, Mr. Soar, and I want to welcome everyone to the North Carolina Court of Appeals. I am Judge Hunter Murphy. To my right is Judge Toby Hampson. To my left, Judge Jefferson Griffin. We are here this morning. There are two cases. There will be a change in panel composition between the first and second case. The first case we have is 20-487, State versus France, and we will be with the appellant.
please the court, I'm Michelle Ligori from the law firm Ellis & Winters for the appellant William France. I'd like to reserve 5 minutes of my time this morning for rebuttal.
Thank you, ma'am.
Police officers can call a K-9 unit to the scene of a traffic stop without reasonable suspicion that drug trafficking is afoot. But under Rodriguez versus United States, if officers do call for a K-9 unit without reasonable suspicion, then courts will assess whether the officers took any longer than they actually needed to carry out the traffic mission of the stop and to address any safety concerns that arose. If they took longer than they actually needed to, the Fourth Amendment requires suppressing any evidence uncovered as a result of the K-9 sniff. Here, Detective Veal called for a K-9 unit after stopping Mr. France for a broken taillight. The K-9 unit arrived 11 minutes later. In denying Mr. France's motion to suppress evidence uncovered from that K-9 sniff, the trial court made two principal errors. First, in assessing whether there was delay, the trial court ignored that there were 4 officers rather than 3 present for the traffic stop. This led the court to erroneously conclude that the stop could not have been completed by the time the K-9 unit arrived. Second, the court found that even if there was a delay, reasonable suspicion supported continuing to detain Mr. France for a K-9 sniff. But the trial court failed to articulate any facts that supported a finding of reasonable suspicion, and its order does not support such a finding.
And if I recall the order correctly, it doesn't say reasonable suspicion for what, correct? And then it also uses an or?
Yes, Your Honor. The order, I believe it's in conclusion of law 3, says there's reasonable suspicion, but it does not say what the reasonable suspicion was for. And I like to just start by addressing reasonable suspicion. As noted just a minute ago, the trial court summarily concluded that reasonable suspicion supported detaining Mr. France to conduct a K-9 sniff. And there are several problems with this conclusion. First, it's important to note that reasonable suspicion requires specific articulable facts. And that was established in Brown versus Texas and is repeated in this court's case law as well. Here, the state didn't argue below that reasonable suspicion existed to detain Mr. France to support a K-9 sniff. And at the suppression hearing, the state did not point to any facts that supplied reasonable suspicion. The trial court also didn't articulate any facts that supported its reasonable suspicion finding. It simply stated both in its oral ruling at the hearing, at the suppression hearing, and in its written conclusions, its written order, that reasonable suspicion existed. The facts in the court's order also don't support a finding of reasonable suspicion. The court did find that this traffic stop took place in a high-crime area at night, but under the United States Supreme Court's decision in Brown versus Texas, those facts did not supply reasonable suspicion that Mr. France was engaged in criminal activity. The court also did find that Mr. Bishop had criminal history, but Mr. Bishop's criminal history didn't supply reasonable suspicion, certainly that Mr. France was engaged in criminal activity. This court's case law, including State versus Cottrell, holds that the defendant's own criminal history doesn't supply reasonable suspicion. And here it wasn't even Mr. France's criminal history, it was someone else's. And Mr. Bishop was found with a firearm in his possession, but Mr. Bishop's possession of a firearm didn't supply reasonable suspicion that Mr. France was engaged in criminal activity. And the Fourth Circuit's decision in United States versus Black addresses this point and says an associate's possession of a firearm does not supply reasonable suspicion that someone else is engaged in criminal activity.
And just correct me if I'm wrong, so I want to make sure I have as much of the facts as possible. The officers in the body cam video have no problem taking care of Mr. Bishop and placing him in custody before the arrival of the K-9 unit, correct?
That's correct, Your Honor.
Okay, and they also say that I think it's the third arriving officer says that he's got you covered if anything happens in the back seat when they're taking him out. All that's clear on the video, that they weren't having any problems with being undermanned at that point?
That's clear. Yes, Your Honor. And because there's no support for the trial court's reasonable suspicion conclusion, that can't support the court's denial of Mr. France's motion to suppress here. I'd like to move on to the issue of delay unless the court has further questions on reasonable suspicion.
I want to ask a question, Judge Griffith. Were you about to ask? I'm sorry.
Yeah, go ahead.
One of the things that may be of biggest concern here is if there's a discrepancy between the testimony before the trial court, and if the trial court finds that testimony to be credible, but that is opposed or rendered factually inaccurate by a viewing of the videos. What is our standard of review in that situation? Are we still dealing with any competent evidence where, trial testimony is competent evidence, but what do we do when there is a direct contradiction there?
Well, I think the competent evidence standard applies, but where a video of the events shows that a testimony cannot be true, I think then the testimony cannot be competent evidence. And I think that can be distinguished from a situation where the video isn't clear and is incapable of two interpretations. And then if somebody testifies as to one interpretation, the court can credit one interpretation over the other. But where it's simply not possible for testimony to be accurate.
And what is your base case law for that premise, either in this state or in another jurisdiction? And if it's another jurisdiction, why is that persuasive?
Well, the U.S. Supreme Court's decision in Scott versus Harris addresses this point. It says that if the video, testimony or allegations are contradicted by a video, then those allegations or testimony are not evidence. That was a summary judgment case, but it said even with a summary judgment standard, if a video contradicts allegations or testimony, then those allegations and testimony aren't sufficient to get to the jury at summary judgment. And I think the same would apply here. If the video simply shows that it's not possible for testimony to have been accurate, then there's no competent evidence in support of that. In evaluating the delay here, it's important to note that William France, his brother, and his cousin were compliant with the officers at all times before the K-9 unit arrived here. The trial court's order found that Mr. Bishop complied with the officers when they took him out of the car. It's in the court's finding of fact 8. And Detective Veal's body cam video shows that after the officers arrested Mr. Bishop, they left him alone in the back of the car for some amount of time. The body cam video also shows that Mr. France and his brother were compliant with the officers during the traffic stop. Detective Veal, in fact, thanks them for that. She thanks them for being chill with her. The trial court's order made several errors about the sequence of events during the traffic stop. The most significant one was that the court ignored the presence of Officer Wagner. In findings of fact 1 and 3, the court finds that Detective Veal, Officer LaValle, and Officer Ferguson were present. There's no mention of a fourth officer in the trial court's order.
And how would that be material to the analysis?
It's material because when it comes to finding of fact number 10, the court finds that Officer LaValle and Officer Ferguson dealt with Mr. Bishop and his firearm while Detective Veal stood by with Mr. France and his brother. But in fact, Officer LaValle and Officer Wagner dealt with Mr. Bishop while Officer Ferguson stood by on the other side of the car. The court found that safety concerns required Detective Veal to stand there until another officer relieved her, but another officer didn't relieve her. There was another officer there the entire time. And so the court erred in finding that Detective Veal needed to be there the entire time because there was not another officer to stand by Mr. France and his brother.
But to what extent are we sort of required to kind of defer to the trial court's findings as far as safety concerns, maybe understanding there may be some sort of evidentiary factual discrepancies between the findings, but generally to the extent that the trial court determines that officer safety required the officers to be there, or at least it was not unreasonable for them to be there. I mean, we're not a fact-finding court. Why should we not defer to those findings?
Well, I think that the court applies the competent evidence standard, and if the trial courts made findings of fact that are contradicted by the evidence, then this court would not defer to those. So when the court makes findings about what happened here that are inaccurate, that are contradicted by the record, and so the court would not defer to those factual findings.
So would the remedy be a remand for a new suppression hearing here?
No, the remand would be...
Or for further fact-finding, really?
I believe the remand would be reversal. The court reviews the order to determine if the findings of fact support the conclusions of law. I think reversal would be appropriate rather than a remand.
To go from where Judge Hampson was going a little bit with officer safety and the trial court's perspective there, are we looking at officer safety as an objective standard or a subjective standard of these officers at the time?
An objective standard applies under the Fourth Amendment as to whether the facts that existed.
So is it of no consequence that, I think it's at 342 in Exhibit 1, the third video, both officers turn their back on the vehicle after already approaching the vehicle? Would that be indicative of an objective review by this court or of the subjective position of these officers, at least at that moment in time, did not feel officer safety was an issue?
I just want to make sure I understand the question. You said there were two officers and they turned their back to the vehicle?
Both of the officers turned their back at 342 to walk back to their unmarked vehicle, with no one watching the occupants of the vehicle at all. So to me, that says subjectively these officers had no concern about officer safety. But if we're applying an objective standard, shouldn't we defer to the trial court's position of objectively what the officer safety situation was at the time?
Well, I think the court has to decide what was actually needed in this case. What amount of time was actually needed based on the facts of this case to complete the traffic stop. The fact that the officers turned their back and were not concerned about safety is relevant in that determination. Generally speaking, a reasonableness and objective standard applies, but what actually happened is relevant in determining what was reasonable and what was actually required.
Is it really your argument that, is this really sort of a chronological argument in the sense of, or is your argument primarily based on this stop just took too long? Or do you contend there was any break in the chain, I guess, of the mission of the stop? Did the original mission of the stop ever end? Thus breaking the chain and turning it into some other investigation, or is your argument simply that, the duration of the stop itself was just unreasonable?
Well, the argument is that the police treated this as an investigation for drugs from the beginning, and they didn't have reasonable suspicion to do that. The law, Rodriguez permits them to do that, but if they do, then they can't take any longer than necessary. So the argument here is that the stop took longer than it should have to complete the traffic mission. It's not that it became an investigation for drugs at some point later. It was always one without reasonable suspicion. And so because there was no suspicion for that, then we look at the time of the stop.
And how long did the stop take in this case?
I think a total of about 13 minutes. There was about 11 minutes from the time the K-9 unit was called until the K-9 unit arrived.
So I guess when we're talking about the timing of the stop, I mean, what are the officers supposed to do when they find that somebody has active warrants and a firearm that they haven't identified upon the stop? I mean, does that not justify
I think
longer?
It was. I'm sorry, Your Honor.
I'm just saying, does that not justify a little bit longer for the stop?
I think it was appropriate for the officers to address that situation, to take Mr. Bishop out of the car and to arrest him for his active warrants. The contention is just that all four officers on these facts were not necessary to do that.
So you have 3 folks in the vehicle, and you're saying that 4 officers is too much for officer safety?
On the facts of this case, record doesn't show that Detective Veal was needed during that.
When somebody has and you're conceding that this person in the back seat had a firearm that was not identified to the officers when they approached the vehicle, correct?
I don't believe he identified it when they first approached the vehicle.
Okay, so just so I'm clear, 4 officers in that situation is too many in your analysis?
I would say on the particular facts of this case, so when Officer LaValle determined that Mr. Bishop had active warrants, he decides to go and arrest him, and he tells the 2 of them are in the patrol car at the time. He tells Detective Veal that he's going to do that. At that point, they don't know that he has a firearm, and Detective Veal gets out anyway to go. She gets out of her car. She tells Officer LaValle to get his name. It looks like she's going to sit back down, and then she gets out of the car, even though there's 2 other officers over there. And the Bishop was compliant during that whole time. He offered the gun to the officers. He complied with the arrest. Mr. France and his brother were also compliant during that time. And so the contention here is that on these particular facts, Detective Veal wasn't needed to stand there with the other 3 officers while this.
Do you have any authority that you can point us to that sort of supports that position, that an officer receiving assistance from other officers contributes to an unreasonable delay of the traffic stop here?
I think the most relevant case would be Rodriguez versus United States, which it instructs that you have to look at what was actually necessary. I'm not aware of a case that's on exactly like this one that involved the same exact facts here. I think the most relevant case would be Rodriguez versus United States, and it instructs that you have to look at what was actually needed for the particular stop in that case.
In this situation, if the K-9 unit had arrived a little bit earlier while they were still processing Mr. Bishop, would that have been an unreasonable extension of the stop?
If the K-9 unit had arrived and finished before the traffic mission had completed, and while then Rodriguez would not be violated. In terms of the delay, it's important to note that the 3 minutes when Detective Veal was standing by the car while the officers were dealing with Mr. Bishop was not the only delay here. Detective Veal testified that after she went back to the patrol car, before she ran warrant checks on Mr. France and his brother, she first checked on the status of the K-9 unit. So that it's not clear how much time she spent doing that, but that was some additional delay. And then when the K-9 unit arrived, she paused her citation writing to go out and greet the K-9 unit. And she did that even though there were 3 other officers standing. So the K-9 unit came in the front. There was the K-9 unit in the very front, then the car with Mr. France and his brother, and then the patrol car in the back. There were 3 officers standing outside the car with Mr. France and his brother when the K-9 unit parked in front of that. And Detective Veal paused her citation writing, got out of the car, and stood for about 30 seconds until the K-9 handler came over. And she didn't return to writing her citations. It took about 2 minutes for the K-9 sniff to be complete. So that was an additional delay spent waiting for the K-9 unit when Detective Veal could have been writing citations.
So I guess kind of following up on Judge Murphy's question, is there do you have a set time for what would have been a reasonable stop in this case? If 13 minutes was unreasonable, what would have been a reasonable amount of time to conduct this stop?
I don't think there's a set amount of time. It's just a matter of whether the officers took any more time than they needed, and that's what Rodriguez versus United States says. It says there's no de minimis exception. This court said the same a little bit earlier in United States versus Cottrell. It's just the officers can only take as long as they actually need for the stop.
And so, I mean, I guess the point being there is no sort of precise mathematical equation to determine what a reasonable stop should be, correct?
I think that's correct. It's a case-by-case analysis.
I want to, it is a case-by-case analysis, but I do want to put a little more math into it. And I'm looking at finding fact 7 on record page 33, where the trial court finds it takes approximately 5 minutes to conduct a single warrant check on the in-car computer system. Was that part of finding fact 7 challenged in the briefs? I didn't recall it being challenged. If it was, please let me know, because the way I interpret that, if that hasn't been challenged and that's an unchallenged finding of fact that's binding on us, then aren't we looking at a 15-minute minimum just to perform what the U.S. Supreme Court has already said is okay in terms of doing a check on a person?
We did challenge that finding
Okay.
of fact in the brief, Your Honor, because it didn't take 5 minutes for each of the warrants here, each of the warrant checks here. I believe it took about 4 minutes for Mr. Bishop's warrant check, and then somewhere around 3 minutes for Mr. France and his brother. And so I do think that's an erroneous finding of fact, and we did make that contention in the brief.
Thank you, ma'am.
And Your Honors, if there's no further questions on the delay, I'd like to just briefly address the trial court's finding on consent.
I'd say one more thing on the
Sure.
delay. What, does it change your analysis when you take into account, how this is progressing as far as they find a weapon that's unreported, outstanding warrants, and then you have drugs involved, possible impaired driving. You have a driver who's driving while license revoked. I mean, I guess, how do you not factor that into your analysis of how long the stop is going to take?
I think again, the stop, the analysis is how much was needed based on on the facts that were present. And there was Mr. France did have a revoked license, but it doesn't take any more time to cite him for a revoked license than for anything else. I think those facts would be taken into account, but I think on these facts, the officers, they took more time than they needed to for the stop.
I mean, I'm just looking at it, this thing is progressing, is the way I look at the way it's coming down, and it looks like they're progressively finding new things that are coming in the middle or delaying the stop. But it's stuff that, an unidentified firearm, finding out that the defendant who's driving has been smoking marijuana, that he doesn't have a license. It just, in that analysis, is that not enough to delay the stop on that analysis?
Well, the finding about the defendant smoking marijuana did not come before the canine sniff. So I think in determining whether there was a delay before that fact would not come into play. In terms of the other facts, they are relevant, but the record shows that the officers could have dealt with them before the canine unit arrived. So Mr. Bishop's firearm is relevant, and the officers reasonably dealt with that. The issue here is just whether they needed all of the time that they took to do the things that they needed to do during this stop. And the argument here is that the record shows they did not.
Thank you.
On the issue of consent, the trial court's order is a bit unclear as to whether the court found that Mr. France consented to the canine sniff or not. To the extent that the court did make that finding is erroneous. The record does not show any consent by Mr. France to the canine sniff. The state, we argued that in the brief. I believe the state did not contest that, but just to address that briefly, there was no evidence that showed consent to the canine sniff. Neither of the officers who testified at the hearing, at the suppression hearing, testified that Mr. France consented to a canine sniff. The video doesn't show Mr. France consenting to a canine sniff. And while Mr. France did testify about consent, he testified that he consented to a search of his person and the car, but that occurred after the canine sniff. And so that consent is would not support the delay in this case.
Ms. Gore, you're coming right up on your rebuttal time. Just to
Okay,
let
thank
know
you,
where
Your
are.
Honors. For these reasons, we ask the court to reverse Mr. Francis' motion to suppress, or alternatively, we ask the court to vacate the civil judgment for attorney's fees for the reasons argued in the brief. Thank you.
All right. Thank you, Your Honors, and may it please the Court. My name is Adrian Dellinger. I'm an Assistant Attorney General with the North Carolina Department of Justice, and I'm here on behalf of the state of North Carolina. The dispositive question in this particular case is whether the trial court properly found that the officers were diligent in their pursuit of the investigation of the traffic violation during the traffic stop, and ultimately the traffic stop itself. A review of the record of the transcripts, and most importantly, the body camera footage shows that there was no delay by the officers on the scene, and each action taken prior to the canine officer arriving at the scene and searching the vehicle was in furtherance of the goal of the traffic stop.
How did asking for the canine to come just a couple of minutes into the stop before even running the background checks, how did that time spent getting the canine contribute to the traffic stop at its purpose and not a potential drug investigation purposes?
It does not. Rodriguez requires that, of course, or allows, and I'm sorry, Illinois versus Cabela's also allows that a drug sniff by a drug dog can happen during a traffic stop. There doesn't have to be a reasonable suspicion that drug-related crimes are afoot. And so here you see that Detective Veal asks for that drug dog to come about 4 minutes into the video. We contend that, I think it's clear that shows that the officers were trying to expeditiously or expedite this stop, to request that early, make sure that the dog had enough time to get there while they were working on the rest of the stop. If they were to request that dog later on in the stop, then they would run into this concern where they're then sort of waiting or even possibly sandbagging the actions that they're taking during the stop just so that the dog can arrive.
But it wasn't just a direct call, was it? Wasn't it, hey, let's look and see where the dog is, they look on the computer, then they make a call in and confirm. So, I mean, you've got at least about 30 or 40 seconds there that's delayed just about the canine, not about the stop. So, kind of tell me why those additional steps. I mean, maybe it's de minimis if they just call in on their walkie-talkie or their in-car system and say, hey, we need a canine dog, here's where we are. But they did a lot more than that.
From my review of the video, Detective Veal and Officer LaValle do look to see whether a canine unit is available and nearby, and then they request that unit. U.S. v. Rodriguez allows for, and Illinois versus Cabela's allows for police officers to request and have these canine units come and conduct searches, sniffs of the vehicle without a reasonable suspicion.
Does the state agree that there was no independent reasonable suspicion to support a drug sniff? Recognizing did not need it, the state's position, this was purely part of the traffic stop.
Yes, although there was some suspicious behavior by the occupants of the vehicle after the very initial encounter and before the drug dog was requested to come. There was Detective Veal testified that the defendant was visibly shaking, that he was fidgeting with his cell phone, that he was telling officers that he didn't do anything wrong. The backseat passenger, who ultimately was determined to have a warrant, told the officers, "I can just walk home from here." Behavior that indicated that there was something suspicious going on. Was there any information that there was necessarily Contraband in the car? No, not at that point. But there was a reasonable suspicion that some sort of criminal activity was afoot.
But the trial court didn't make any finding as to the nervousness or the shaking or anything like that, did it? I believe that's what the defense says in a footnote somewhere.
That's correct. So based on the findings of fact that the judge, that the trial court made, then no, there is no, there was not reasonable suspicion at that time for a drug investigation. But there's certainly, there was, there's no de minimis, as Rodriguez says, there's no de minimis delay allowed for. But there's got to be some delay that's allowed for to simply identify and call a canine unit to come to the scene.
Well, what
No
impact
more
does
than
it
just a
have
few
that
seconds.
before they even do that, if I'm recalling the video correctly in the time, they're expressing their hunch that these people are druggies and drug users dealing drugs. They're expressing that on the video before even reaching out for the canine is my recollection of the video, when they're looking at their IDs. Is that right?
I reviewed the video. It was difficult to hear some of the audio that may have been what they were saying. I wasn't clear as to what they were saying. I did hear them, the officers expressing concerns about the suspicious behavior of the individuals, though.
What do we do, also with this false statement that Officer Veal makes to the canine unit when it arrives, saying they saw a hand-to-hand transaction beforehand? And that's not anywhere in the transcript. That's not in her testimony. It's not in the video. Nothing found by the trial court on that. But what do we do with this blatant lie to a co-officer upon that officer's arrival to try to suggest to that canine officer why they should be searching this car?
Well, I don't think that this court needs to do, let me straight that. This court does not need to take that into account. It would not have affected the purpose for the canine search. The canine search was conducted almost immediately upon the canine officer arriving. You see the other officers on the scene as Detective Veal exits her car to go greet the canine officer. You see the other 3 officers who are on the scene, carefully extricating the 2 remaining occupants of the vehicle, including the defendant. And of course, and Detective Veal testified that that's because they needed the car to be unoccupied while the drug dog conducted its sniff. So the way, let's see here, it is certainly clear that the trial court was correct in finding that the officers diligently pursued their investigation. Traffic stops cannot last longer than what is necessary to address the traffic violation that warranted the stop and to attend to the related safety concerns. Here only one period of time, there's only one period of time this court needs to consider. The time between when the defendant pulled his car to the side of the road and when the canine unit arrived at the scene. At 57 seconds into Detective Veal's body camera, that's when the stopwatch starts. That's when the defendant finally pulls his car over to the side of the road. At 13:20, our stopwatch stops. That's when the canine unit arrives at the scene and the other officers begin pulling the defendant and the other occupant out in preparation for the canine search. This is a period of 12 minutes and 23 seconds. In the abstract, this is totally reasonable amount of time. But in addition to that, time was needed to question the defendant as to whether he was aware of the broken taillight and ask why it was broken. There were 3 passengers in the vehicle, each of whom needed to be checked for any outstanding warrants. There was time needed to check the defendant's ID and the vehicle's registration. All of these things are identified in U.S. v. Gonzalez as appropriate inquiries during just a normal traffic stop. At no time in my review does the Detective Veal or any of the other officers ask questions related to any topic other than the current traffic stop and officer safety or the license issue or anything related to the subject who had the warrant in the back seat. All of this is needed. All of these things that were done were needed to make sure that the encounter was done in a safe and secure manner.
I think part of what Judge Murphy was getting to, and at least, or maybe I'm getting to it is probably the better way of putting it. You know, what do we do with that statement when the canine officer arrives and is told we saw a hand-to-hand transaction? Isn't that not a fact suggesting that the mission of the stop had never been a traffic stop, but had instead been a drug investigation without reasonable suspicion to conduct a drug investigation?
I think we balance that, that statement and one statement that, I'm sorry, I just didn't hear from from my review of the video. We balanced that statement against everything else that was done during the traffic stop. You know, the Detective Veal and Officer LaValle go up to the car, they ask the initial questions, they ask for a driver's license, which the defendant is unable to produce. Instead, he produces an ID card. That ultimately resets our stopwatch, because at that point we're not we're not investigating a traffic stop based on a broken taillight. We're investigating a traffic stop based on a broken taillight and the fact that one of the driver may not have an appropriate license.
And that seems to be one of sort of the inherent conflicts or the inherent tensions in this case, is that on one hand you have what generally appears to be a fairly reasonable traffic stop, you know, with each you know, sort of points along the way, kind of creating further reasonableness, you know, outstanding warrant, driving while license revoked, you know, but there's the subtext here, which is, you know, at the end of the day, these officers were not interested in a busted out taillight, right? There was potentially a drug investigation going on based on a hunch, based on, you know, unparticularized suspicion. And so I think that's the inherent tension of this case that we're trying to grapple with here, you know. And so, and I guess the question becomes, to what extent did the trial court grapple with that very question?
I think,
I guess I'll ask it like, I'll chime in as well. So do you concede this is a pretextual stop? I mean, that's what we're talking about. I mean,
absolutely not. I don't think there's anything pretextual about the stop.
I'm not saying it's illegal, but do you concede this was a pretextual stop for something other than a tail light? I mean, it's legal to pull them over for that, but do you concede that they had other motives here?
No, because I can't speak to what the officer's motives were, just based on the information that's contained in the transcript and the video.
Is the best evidence of that then their statements about that?
I'm sorry.
Judge Hampson, isn't the best evidence of that then what they said about thinking these folks are involved in drugs, and then making call it misrepresentation, call it a lie, whatever she did to the canine officer, giving her wrong information on why they pulled this vehicle over to begin with? Doesn't that all point to a pretext?
Again, no, Your Honor, because I think we look at what they actually did during the stop, not necessarily what they said. You have a broken taillight, that gives you reasonable suspicion to pull the car over and conduct an investigation.
Right, and I'm not saying that they can't do that based off of the taillight, but you know, just like I kind of equate it to a checkpoint, right? That's per se unconstitutional, a random seizure. So everything's got to be perfect subsequent to that for a checkpoint. So you make a pretextual stop, yeah, but everything's got to be perfect. And that's what I'm saying. Do you not concede that this is a pretextual stop?
No, Your Honor, we don't concede. We believe that based on the findings of the trial court and also the information, you know, the testimony of the officer, the video clearly shows that there was a reason, and the reason for the stop was what drove the investigation within the stop. The pulling over the car, the, you know, discussion about, you know, why the taillight was cracked. That moved on to an investigation about why Mr. France didn't have an active driver's license. It was revoked. They find that out. Doing the simple warrant check determines that the rear passenger has a warrant for his arrest. As that passenger is being pulled out, the officers find out that he has a firearm, so officers have to respond to that in a safe way. Then Detective Veal goes back into the car to complete the citations and the warrant, looking at, I believe, the warrant search for the other two occupants, Mr. France and the front seat occupant. And it's at that point, and also I believe she's interrupted by the backseat passenger who's now been handcuffed and placed in her car. At that point is when the canine unit arrives. So everything that was done, actually done by the officers in that video is related to those reasons for the traffic stop. What may be in their mind is something that we can only presume. At this point, the actions are what speak loudest. And so at each of those points, we reset the stopwatch. At each of the points where the officers find some other evidence of the potential for other illegal conduct, that gives them reasonable suspicion to then extend that investigation into those matters. The fact that the driver didn't have a license, the fact that the backseat passenger had an active warrant, the fact that the backseat passenger was in possession of a gun that he did not disclose to the officers when the officers first arrived at the car. All of these things reset that stopwatch. Each of them allowed the officers to continue their investigation and detain those three individuals, including Mr. France, at the scene for a longer and longer time. And
So even given that, would it not be, I mean, was the charging officer there, was she, did she have a problem with writing the citation, handing it to the driver, and then continuing the other investigations? Would that be best practice?
I don't believe so. I think the officer, let me make sure I understand your question, whether the officer should have gone ahead and drafted up the citation and then given it to the defendant and then gone back and conducted the rest of her investigation.
Would that not get us past this point? I mean, would we be here if that happened?
I think so. I think, in fact, defendant would have probably pointed to that as saying the traffic stop's over. She's given him the citation. At that point, everything after that is just an extension. The officer has to have some discretion on how they prosecute this traffic stop when they hand over the citation or when they do the warrant search. There's nothing in U.S. v. Rodriguez that requires that things be done in a particular order. It's just that everything that is done during that time period has to be related to either the initial stop or to officer safety, or has to have its own unique individualized reasonable suspicion that's developed during the stop itself. And here, everything that was done falls into those three categories. It is either relevant, either related to the initial stop, or it was, in furtherance of officer safety, or, and most importantly, most of what was done was based on reasonable suspicion that was identified by the officers during the stop itself.
Wouldn't a diligent execution of this traffic stop put a focus on, if we put officer safety aside, put a focus on timely resolving a deprivation of a citizen's liberty, as opposed to which order they decide to do different things in? To get back to Judge Griffin's question, why not do it first? Why not end your deprivation of this driver's liberty when you can and you can't be done? Wouldn't that be the most diligent thing to do, instead of these other activities with the canine, these other activities of waiting until other things are all handled when you could resolve it? Why is that not diligent and the diligent activity under Rodriguez?
So as I understand your question, the extension, I think the question then becomes, why didn't they just stop the traffic stop earlier than they could have? Because the position here is that in accordance with U.S. v. Rodriguez, everything that was done appropriately and within the bounds of U.S. v. Rodriguez. That there was the detention of the people at the scene, the driver and the two passengers, was because of an investigation that yielded reasonable suspicion of more criminal activity. You know,
For what
at
criminal
no point-
activity? Reasonable suspicion of what criminal activity?
So first and foremost, a broken taillight, that's what caused them to pull the car over. At the point that the defendant turns over a identification card instead of a driver's license, that's reasonable suspicion that the defendant is driving without an appropriate license. Most likely, and as it turned out here, that he's driving with a revoked license. And so there's there's investigating that. Why did he give me an ID card and not an actual license? And then US v. Rodriguez does allow for certain things that are related to officer safety, including conducting searches, checking vehicle occupants for warrants, and that's what was done here. Three vehicle occupants, each of them were checked for a warrant. The back seat passenger was checked first, and his name popped up. And so at that point, you have probable cause to arrest him because there's a warrant out for his arrest. So you go and you pull him out. And then at that point, he identifies, hey, I've got a firearm. That's an officer safety concern where the officers need to make sure that they secure that firearm. And also you see Detective Veal go to the driver's side of the car and make sure that at that point she asks the other two occupants, including the defendant, to put their hands up on the dashboard to protect the officers, to make sure that the hands were seen so that they wouldn't do something themselves, pull out a weapon that they may have had or attempt to drive off.
Let's assume you get me all the way to that point, that everything's good up until taking Mr. Bishop out of the back seat. Once Mr. Bishop's out of the back seat, how do you get me from that moment to when the K-9 unit arrives?
So you have an occupant of the car who has an outstanding warrant.
But that's done. He's in custody. He's gone. They've taken care of that. They've eliminated that risk with his weapon. That's gone. He's in custody. They handcuff him right there outside the car. You hear him talk about the rod in his arm. So he's in custody. So they have taken care of that part of the additional investigation. From that point, the passage of time until the K-9 unit, how do we get through that?
Certainly. There's a certain amount of time needed for the officers to address, to be at the car to make sure that everything is being done safely. He's arrested, but also found the gun, so they need to secure the car and the occupants to make sure that nothing else happens that could, impact officer safety. At that point, Detective Veal goes back to the car and starts conducting the other warrant searches and working on the citations. And she is doing that when the K-9 unit arrives. And so everything that's being done is in furtherance of one of those sort of legitimate, justifiable investigations that's based on reasonable suspicion. None of them are based on a reasonable suspicion of a drug crime. They are based on a reasonable suspicion of some other type of crime.
Why did they get the remaining the driver and the passenger out of the car only when the K-9 got there? I mean, what would the reason of that be?
I'm sorry.
So they only, as I recall, they only got the passenger and the driver out of the vehicle when the K-9 got there.
That's correct. They did that because the K-9 unit needs to search the vehicle when it's unoccupied. So they pulled the driver and passenger out so that the K-9 unit could conduct that search.
They can't do a K-9 search while they're in the vehicle?
The officers testified that no, they pulled they pulled the occupants out, and I believe that's also an officer safety concern, to have the occupants out of the car when they have the dog do an exterior sniff.
So it wasn't an officer safety concern before that point to still have them in the vehicle?
It doesn't appear to, although you do see Detective Veal, when they are pulling the backseat passenger out to arrest him for his warrant, you do see Detective Veal go up to the driver's side door to make sure that the other occupants of the vehicle are not doing anything suspicious or that could be dangerous. In fact, that's when she asks them to put their hands up on the dashboard. So there's different safety measures that are taken by different officers at different times. While the backseat passenger is being taken out, that's when they're making sure that the other occupants stay in the car, but also keep their hands where they can be seen. When the when the canine unit comes, that's when the other officers, you can see them, the minute that car shows up, the other officers are pulling the other two occupants of the car, including defendant, out of the vehicle.
How do we deal with some of the sort of the factual discrepancies between the findings of fact and the evidence identified by your colleague? How do we deal with those sort of discrepancies?
So, looking at the findings of facts and conclusions of law in the trial court order, the inconsistencies identified by the defendant are just not there. When you look at paragraph 6, the defendant states in his brief that the finding of fact is after Detective Veal approached the stopped car, she asked Mr. France for his license. Defendant argues that this was erroneous because Detective Veal waited 1 minute before engaging with defendant. This is sort of mischaracterizing or reading into the findings of fact that there was some immediacy. It wasn't. It was minutes worth of difference. Paragraph 7.
Well, I guess specifically the findings of fact concerning which officers were actually on the scene and engaged in the traffic stop. I mean, how do we address that? Because I think the argument we've heard from your colleague is that that does impact the reasonableness of the duration of the stop, with the interactions with the various officers, whether or not the stop may have been conducted more diligently because there were other officers on the scene who could be conducting other aspects of the stop.
So this goes to, I think, defendant's argument that there was that Detective Veal decided to join the other 3 officers who were already pulling the backseat passenger out. This is a question of what the officers, I mean, and an objective standard of what the officers would feel is reasonable. And when you have three subjects in a car, one of which who has a warrant, and then ultimately that same one who has a gun, it's perfectly reasonable that the officers would feel that they needed to have 4 people on the scene at that place to deal with that. State v. Campbell states that police officers are authorized to take such steps as are reasonably necessary to protect their personal safety and maintain the status quo during the course of the stop. That's exactly what happened here. 2 officers plus 2 officers were pulling the backseat passenger out. Another officer was at the driver's side door. Once the gun was found, that's when Detective Veal goes to the driver's side door, and the officer that was at the driver's side door sort of goes to the back of the car. I know there was some confusion in the order as to the identities of those officers, but I think ultimately the facts are correct that there were 3 officers at the car at the time that it was pulled out, and then Detective Veal had to go up again for officer safety reasons. There was, the last sort of, and this sort of dovetails into the factual finding that defendant challenges in paragraph 10. The defendant claims that safety concerns did not require Detective Veal to delay the warrant checks and citation writing to stand by Mr. France, who was already being watched by Officer Ferguson. The trial court found that Detective Veal stood outside the defendant's window as a safety precaution, and that finding, unless there's no competent evidence to support it, is not reviewable here. There's plenty of competent evidence to support that Detective Veal moved to that position for a reasonable reason. I know Your Honor mentioned that at about 3 minutes and 42 seconds, both officers turned their back to the vehicle as they left. I think I would point out that that happened well before any warrant checks. That the officers probably may not have had that concern at that point. Obviously, they demonstrated they didn't have that concern at that point, but once they got back into the car, they started running warrants. They then pulled the backseat passenger out who had a gun. Obviously, they're developing more and more concerns and taking greater and greater precautions for their own safety. The U.S. versus Rodriguez prevents officers from prolonging a traffic stop beyond the amount of time reasonably required to complete that stop's mission. Here, the initial mission of the stop was twofold: to investigate the broken taillight and to do so while protecting officer safety. However, this simple investigation quickly morphed into something much more complex. Defendant was found to have a revoked license. That's reasonable suspicion. One of the passengers in the vehicle was found to have outstanding warrants and then ultimately a gun. That's, again, more reasonable suspicion that there was additional crimes afoot. The testimony presented at the suppression hearing and the video from the officer's own body cameras clearly show that Detective Veal and her colleagues conducted their investigation diligently before the canine officer arrived. The trial court did not err when it denied defendant's motion to suppress, and its decision should be upheld here today. The trial court committed no error, and this court should affirm in every respect. And unless anybody has any questions, that's the red light.
Judge Sampson, anything else?
Thank you, Your Honor.
Thank you.
Ms. Legore?
Your Honors, I'd like to address or to focus on two issues. The first is that Rodriguez chose a time-based standard for dealing with pretextual traffic stops. It didn't prohibit pretextual traffic stops, but it said that if the officers do conduct one, then the court will assess whether the officers actually needed all of the time that they took to do the things that they needed to do for the traffic mission of the stop and for safety. And the record here shows that the officers did not need all of the time that they took. There were 3 periods of delay here, including the 2 minutes when Detective Veal got out of her patrol car while she was writing the citations for Mr. France. And those 2 minutes included when she went out of the car to greet the canine unit. There was an additional period of delay before that when she paused her citation writing to check on the status of the canine unit. And then there was a period of delay before that of about 3 minutes when Detective Veal was by the car while Mr. Bishop was being arrested. All 3 of those periods of delay violated Rodriguez. The second point is that it was the state's burden at the suppression hearing to prove that this stop was constitutional. The state did not meet that burden here, and for that reason, and the reasons argued earlier, the denial of Mr. France's motion to suppress should be reversed. Thank you, Your Honors.
Judge Sampson?
Good stuff.
Thank you, ma'am. Thank you all for your arguments. The case 20-487, State versus France, will be submitted, and this court will stand in recess as we adjust the panel and comply with all of our COVID guidelines. Thank you.
All rise. Court is in recess. Thank you.